Well, now that we answered the first $1 million question, of course, that leads us to the second $1 million question, which is everybody wants to know is that what happens if Wendi Adelson committed perjury while she was on the stand? What is that going to do to her grant of immunity? As we spoke about in our last video, and if you haven't seen that video, you got to check that out. That really goes through the whole analysis of the use and derivative use immunity, using the Casker case, how this all works, how to understand it all, really gives you a really good basic understanding of how this all works and why, which is important, as we're going to get into more in this video. To understand the rationale behind this all is very important when we're continuing to analyze this type of immunity under the law. So Wendi was granted use and derivative use immunity. What happens if she committed perjury? That was one of the questions. We're going to get to that question a little bit later in the video. But there's some other questions that came up that I thought were also very good. So one of the questions that came up was, why would a prosecutor ever grant full transactional immunity? After all, the only thing that she's required to under the statute is to give use and derivative use immunity. That's all she's required to do. So why would a prosecutor ever grant someone full transactional immunity? And by the way, just for a little side note on the procedure and how this is done, because I saw some of this over the weekend, some of this case law, that if somebody receives a subpoena in the mail by a prosecutor, so if you're in Florida and you're watching this, this is important. If you receive a subpoena, you don't automatically get the use and derivative use immunity. Just by receiving a subpoena, that's not considered that you're compelled to testify. What you then have to do is you actually have to then assert your Fifth Amendment right to remain silent. After you do that, if the prosecutor continues to want to, if he or she wants you to testify that badly, then she will then issue another subpoena, and in that subpoena grant you use and derivative use immunity, and at that point you've got the grant and you're compelled to testify. So just so you should know, the case law that I saw over the weekend was that just by receiving a subpoena is not considered that you're compelled. Okay, but that's just an interesting aside for all you lawyer nerds out there like me. Okay, so now that's with that. Let's move on. So why would the prosecutor ever grant full transactional immunity if all she is required to offer is use and derivative use immunity? So I think that the answer to this could be simple. It could be there's more moving parts to this, but the first thing that jumps out to me is that still a person is going to be more forthcoming if they have full transactional immunity, which means that they're never going to be charged with anything to do with this case. Then they will completely be candid on the stand. That you don't have to worry about them lying. They'll just spill all the beans as much as they want because they know there's no way that they're going to be charged with anything to do with this case. So still, if you want your witness to completely be candid, and it would certainly work in an example where you have somebody who was not one of the major players in the crime, someone who did something small, and but they have the beans on everybody. And if you get them, if you get them to testify candidly and openly and transparently on the stand, then you'll be able to lock up all the serious players. It may be worthwhile for you to offer them full transactional immunity, and that way you'll be able to get the major players involved who committed the major crimes, and then this person can get off. Not the biggest deal. So that's one idea why a prosecutor would ever grant full transactional immunity. Another question that came up is, why didn't Wendi just admit everything on the stand? We spoke about in the last video that when you're granted use and derivative use immunity, it may be a good idea to say more than generally you would say, because the more that you say, technically, the more protections that you have. Unless, of course, which a lot of people have mentioned, that unless there's been a lot of already evidence that was discovered before you even giving testimony, which is enough to lock you away. But if you feel as the witness that they don't really have so much of a case without your testimony, then of course the more that you testify, the more that you give them, the more protection that you have, because the use and derivative use immunity says that anything that you say and anything that they derived from your testimony cannot be used against you. So if that's the case, why wouldn't Wendi just completely spill the beans? Just say everything? Well, I think there's two reasons. Number one is that she does know that she could be charged from other independent legitimate evidence, as we spoke about in the last video. It's just, the protection is just for what you say on the stand. If the prosecutor has all this other evidence against her, which a lot of people suggested that she does, if she does have a lot of this other evidence, and it could be that she's sitting on a lot of evidence, and Wendi could be thinking about this in the back of her mind, then she's not going to want to just come out and deer the prosecutor by saying, yes, I was involved, now come and get me, and try to use your independent, legitimate way of proving that. So not such a smart idea for Wendy to just get up there and completely admit to everything and then have this process and then have the prosecutor try to convict her, with the independent, legitimate ways of doing it. So that's one reason why Wendy would not want to get on the stand and admit it. Number two is that if Wendy really thinks that she's going to get off on this case, and she thinks that the only way that the prosecutor can put her away is through her own testimony and the things that the prosecutor derives from her testimony, the use and derivative use, and therefore Wendy is completely confident. Let's just play the scenario out. Again, I'm not suggesting this, but let's just play it out. Even if she would be so confident in herself to say that there's no way that they can lock me up without using something that I'm saying in my testimony, still she has a life to live outside of the courtroom. So you're right, she's not going to be living the rest of her life behind bars, maybe, but even if she gets off, she still has these kids to raise. She still has to have interactions with other parents, with teachers, with a community that she lives in. And everyone's going to know what happened. If she gets up on the stand and completely admits everything, who's going to want to have anything to do with her? And who's going to want their kids to have anything to do with their kids? So it's not, even if it's technically under the law, she won't be locked away, but it's not something that she would want to admit to just straight out and let everybody know that she's a murderer. So that's another reason. Now let's get to, finally, the $1 million question, the second $1 million question in this case right now as it stands. I'm sure there'll be more $1 million questions as we go along. But what about the perjury? What about the perjury if that she committed? And again, like I said always, I don't have any opinions about this case, personal opinions. That's not what I'm here to do. I'm just here to give you the analysis. So let's assume that Wendy committed perjury on the stand. So now, what's that going to do to her immunity? So in order to understand, like we always do, we have to get back to how we got here. How do we get to this grant of immunity? And if we understand the rationale behind everything, then that will help us to analyze, if she commits perjury, what that should mean to her agreement, her grant of immunity. So remember, let's start from the beginning. We had the Fifth and Sixth Amendment tension. We have the Fifth Amendment that guarantees that I do not have to testify against myself. Then we have this other person's Sixth Amendment rights, which guarantees that he can force me to testify on his behalf. So that's where we get to this tension where I'm forced to testify for him, but at the same time I can be saying testimony that will incriminate myself. So this is a real tension in the Fifth and Sixth Amendment. So how are we going to get around that? That's where the Castigar case came, and the Castigar case said that we obviously have to grant immunity. We have to grant immunity to the person who's testifying, so that way his Fifth Amendment rights will be protected. You can't use what he's saying against him, and that person's Sixth Amendment right will be protected as well. So great. Wonderful. Everyone's getting along. He's got his Sixth Amendment rights. You've got your Fifth Amendment rights. Everything's wonderful. But it's not as simple as it may seem. Why? Because what's going to guarantee that you're saying the truth? You're right. You're dragging me into court. Your Sixth Amendment rights allow that I get dragged into court. So now, but what's going to make me say the truth? If I have absolutely no repercussions for anything that I do or say in court, then what in the world? What's it going to help? I can say whatever I want, and I have no repercussions. So if that's the truth, if that's how it is, so I'm going to get to the stand, I'm going to lie all day long, and nothing to do. No one can do anything about it. So then we're back to square one. Well, that guy has a Sixth Amendment right that I say the truth, and that I say why he's innocent. But if I don't have anything that's forcing me, compelling me, or penalizing me for not saying the truth, well, then why would I not say that? Well, I just won't say the truth, and nothing can happen to me. So now we're back to the problem. Well, now that guy's Sixth Amendment right is not being protected because I'm not going to say the truth. Well, maybe we should force you that you have to say the truth. Well, hold on. If you're forcing me to say something that I have to say the truth, which means that there's going to be some sort of penalty attached to me by my testimony, well, now you're taking away my Fifth Amendment right. My Fifth Amendment right is to not incriminate myself. And you're forcing me to say something which there's going to be consequences if I lie about. So now, essentially, I'm being forced to testify, and my testimony can incriminate myself. So now my Fifth Amendment rights are being violated. They're not being protected. So you're right, you're protecting that guy's Sixth Amendment rights, but you're not protecting my Fifth Amendment rights. So when it comes to this question of how we're going to guarantee that this person who's being dragged into court and being compelled to testify is going to say the truth, we're back to the same conundrum. We're back to the same tension. We're back to the same problem. How are the Fifth and Sixth Amendments going to work together here and to protect everybody involved? And remember, it's utmost importance that everyone's rights are protected as much as we can. Right? That's the understanding. So what the courts have realized, and because of this tension, is they realize that we have to make this person say the truth. We've got to. We can't have this person coming into trial and just being able to lie with a free get out of jail card with just being able to lie. We can't let that happen. So therefore, what the courts have decided, and again, this is from my research, if anyone's seen anything different or have any other lawyers that are telling that the law is different, I would like to know. I'm interested. I like to be educated myself. So if there's any other case law that says anything different than I'm saying that you see from other channels, please let me know in the comments so that I can look them up myself and do some more research on this topic. But from what I've seen is that the cases, the opinions have told us, the courts have told us that we have to take away a little bit of that person's Fifth Amendment rights. That's just the bottom line, because we have to make this person say the truth. And if the only way to do that is to impose some sort of sanction, some sort of penalty for the person not saying the truth, then we're going to do it. And that way, that person's Sixth Amendment right is completely being protected. My Fifth Amendment rights are mostly being protected, but for this area, we're going to chip away a little bit on we're going to make you say the truth. But what's the penalty for not saying the truth? So let's think about this. If the penalty for not saying the truth is that everything that you said now can be used against you, well, then you don't have any Fifth Amendment rights then anymore, because everything that you're saying now can be used against you. So you're right. You committed a perjury. You lied about something in your testimony. Let's say you're giving testimony for a week and you lied about one thing. One thing you lied about because you thought you don't like your weight. And they asked you how heavy are you and you lied about your weight and you knew about it and you completely committed perjury and you lied about it. So now that means your whole week of testimony now they can use against you. That's not fair either. So the courts understand this. The courts understood that we still have to protect your Fifth Amendment rights as much as we can. It's just that we have to impose some sort of penalty on you for lying under oath. So therefore, what the courts have held, and this is what I've seen, is that you can still be charged with the crime of perjury, but we're not going to strip away your immunity that you have under the Fifth Amendment. We're not going to do that. But we are going to give you some sort of penalty for perjury, which would be that you can be charged with perjury. And whatever the crime and whatever the sentence for that is, you're going to have to deal with. But it's just limited to the crime of perjury. So it doesn't work like a contract where if you have a contract and you breach the contract, then the whole contract can be technically thrown out and you don't have to abide by the contract. So if Wendy lies, that means that she loses all her immunity. That's not the way it works. And again, this is under the strict letter of the law. I don't know if there can be separate contracts between the prosecutor and a witness, where the prosecutor can have a separate deal in a separate contract that we don't see, that if they don't say the truth, then they're completely being stripped of their immunity. I guess that's possible. That's, you have to kind of think of all possibilities. But if they follow the exact letter of the law, which is what I've seen, the letter of the law, and they just did everything according to what the statutes in Florida and the case law in Florida says, at least from my limited research that I did, it would appear to me that the only thing that Wendy could be charged with is just perjury and not anything to do with this crime. And I'm just going to read for you the statute. This is the statute, Florida statute, section 914.04. And there's a very similar federal statute as well, but this is the Florida statute. And the first part of the statute really just discusses the immunity, that a person's granted immunity and anything that they say cannot be used against them for the crime that they're talking about. But at the end of the statute, this is what it says. Such testimony or evidence, however, may be received against the person upon any criminal investigation or proceeding for perjury committed while giving such testimony. So what you say could be used for a proceeding for perjury against you. So that's the proceeding that your statements could be used against you. But again, they're not taking away the grant of immunity. They're not taking away that your Fifth Amendment right to remain silent. That they're not taking away, and you still have immunity for the crimes that you're talking about that you committed. It's just the crime of perjury. So that is my take on it. That's my understanding. If you see anything or any other channels or any other lawyers that are discussing this that say that they feel differently about this and that once she committed perjury, then she loses her immunity, I would like to see I would like to see the case law or the statutes that they're referring to. I would like to be more educated about this. But from my research, this is what I've uncovered, and it also kind of makes sense with the rationale of how we got here in the first place, using the Fifth Amendment, the Sixth Amendment, how to weigh everyone's rights against each other. And it would make sense to me that the minimum amount that you can take away, that's what we take away, and that's why we're just taking away the fact that you have to say the truth, and you have to, and if you don't, then you're going to be charged with perjury. But everything else, all your other Fifth Amendment protections remain in place. So that's what I would think. And please, if you haven't yet, subscribe, like the video, and we will see you next time.